One of the fundamental principles of good governance, among other things, is to strike fine balance between the authority of state or institutions of state on the one hand and rights of people on the other. Are you getting a point? If we end up conferring too much of authority on the state, then there is a risk that the state institutions might trample over the rights of the people. And if we confer too many rights on people, then the body of the state would be shackled by the claims which would be exercised by individuals, groups and communities over it in the form of rights. It means too many rights conferred on the people and too much of authority conferred on institutions of state. Both of them could be dangerous and can easily disturb the smooth functioning of the government within a society. So therefore, institutions are required to be conferred with appropriate amount of authority so that they could discharge their responsibilities effectively and efficiently. If authority is in excess of responsibility, it can be misused. And if responsibilities given to state institutions, if responsibilities are more than authority, so in that case it will be meaningless. With limited authority, institutions will not be able to discharge their responsibilities. Same is the case with the rights of people. Excess of everything is bad. And if things are deficient, that too will be bad. That's why one of the fundamental principles of good governance, whatever be the nature and form of polity, whether it is monarchy or it is democracy, one of the fundamental principles of good governance is to ensure one of the fundamental principles of good governance, you can say it demands that the distribution of authority on the one hand and rights of people on the other, or the equation of relationship between authority of the state on the one hand and rights of people on the other is required to be done very, very carefully and very prudently. Point is clear? Now come to another dimension. It is to be noted that every institution of state, I repeat, it is to be noted that every institution of state is nothing but a social entity institutionalized to accomplish certain goals and purpose. Getting a point? And every institution therefore, or you can say every institution operates within the bounds of a society. Institutions affect society in the course of providing goods and services, and they get affected by the society because society and its people, they exercise their rights over the institutions. They reserve the right to criticize the actions of the institutions. They also call for the enforcement of accountability. So what I mean to say, that institutions do not operate in vacuum. Institutions are like social entities. They operate within the bounds of a society with which it is related in a mutually influencing construct. So institutions affect people's life and it gets affected by the people. So institutions affect and get affected. But remember, when any institution is operating in a society, things may not be so much easy to understand that all such, influences you affect and you get affected. Everything cannot always take place on positive note. There can be influences which may be negative in orientation. There can be integrative forces in society. There can be disintegrative forces in society. So therefore, successful and smooth or efficient functioning of institutions, among other things, demands that in the course of interaction with one or the forces in society, it must steer smoothly through the negative forces and harness the potential of positivity so as to provide best of goods and services to society. I give you an example. Institutions may be criticized by people, but all criticisms are not same. You may have people or groups or communities who criticize institutions, with a positive note, constructive criticism, because their main concern is to improve the quality of services, to make the institutions more relevant. But in the same society, there can be certain groups, certain communities, certain political entities who might prefer to criticize institutions in furtherance of their oblique motives and interests. Unnecessarily, they can create one another kind of problems, inhibitions on the path of functioning of such institutions. Getting a point? There can be conspiracies or there can be strategy to interfere with the independent functioning of such institutions, to inhibit the exercise of authority by such institutions, to discredit such institutions, to come up with criticisms with oblique motives, to question its credibility, to interfere with the exercise of its authority, to scandalize it for one or the purposes, motives or interest. So therefore, successful functioning of any institution or smooth functioning of institutions does not merely demand that within the four walls of it, resources are being utilized prudently, resources are being utilized efficiently and effectively. There is another side of or another dimension of the successful functioning, and that is that the institutions should have healthy equation of relationship with the society, so that in the process of affecting and getting affected, it is constantly making some kind of value addition, and such process of influence and counter influence should not dissipate its time, money, energy, its strength, its credibility. Genuine criticism is always welcome, but criticism or interference with the exercise of authority with oblique interest and motive could be dangerous. That's why important institutions, more particularly the constitutional bodies, whether it is legislature or for that matter executive and judicial institutions, they are provided with some kind of safeguards, either through one of the provisions in the constitution or through one or other laws enacted by the parliament. But institutions are required to be provided with certain safeguards so that it could exercise its authority with due rationality, objectivity, with due independence. Getting a point? So that its independent and impartial functioning could not be interfered with and could not be disturbed by others. But this is not possible only by making moral appeal to the people, groups and society and institutions. This cannot be done only by moral persuasion. Institutions therefore are required to be conferred with appropriate amount of authority or one other kind of legal devices or instruments in hand, so that they could deal effectively with this kind of oblique interests and motives. It means if any institution or individual is found to be interfering with the exercise of authority of such institutions must be capable of taking cognizance of such cases and to apply appropriate correctives. They should be conferred with authority and power to punish those individuals or groups who deliberately interfere with the process of smooth functioning of such institutions. Points clear? Accordingly, as we have discussed, that the legislature, parliament, Lok Sabha and Raj Sabha, legislature, parliament enjoys certain immunities and privileges. Parliament as an institution has been provided with certain privileges, certain immunities, and individual members of the Parliament also enjoy certain immunities. Why? So that Parliament as an institution, as a pantheon of democracy, could function smoothly and without any fear, without any inhibition, so that nobody could interfere with its business. Getting a point? And if anybody dares to do so, Parliament should not be made to stand as a mute spectator. Parliament, or those who are responsible to defend the institution of Parliament, those who are the president of such institutions, they should be conferred with some discretionary power to take cognizance of such cases which involves unnecessary, undue interference with the authority of such institutions, or scandalizing such institutions, so that such cases could be taken cognizance of, and the culprit should be adequately punished. That's why Parliament has been conferred with certain immunities and privileges. Similarly, our courts, Supreme Court and High Courts, our judiciary too has been conferred with this kind of protection. Though our constitution does not deal with contempt of court, but there is a law enacted by the Parliament, Contempt of Court Act 1971, wherein some safeguards have been provided. There are some provisions wherein the Supreme Court can punish in those cases where it is found that there has been deliberate attempt to show disobedience to the authority of the court, or to do something which scandalizes or lowers the authority of the court. This is the kind of safeguard I was talking about. Getting a point? So judiciary as an institution, I'm talking about Supreme Court and High Court more particularly. Don't you think that our courts too should be provided with such kind of safeguards, so that their independent functioning could be facilitated, so that if anybody interferes with the authority of the court or with the process of administration of justice, courts should have adequate powers in hand to punish those individuals, groups, or institutions. This is something which in togetherness, if at one place, if you ask me what is that legal instrument which has been designed to provide such safeguard or protection to the courts, this is known as Contempt of Court Act. So it is a statutory protection, you can say. Contempt of Court Act 1971. This law was passed by the Parliament. Under this law, although the contempt of court has not been clearly defined, and again it is very much difficult to define, within four walls of words, it is difficult to define contempt of court. But this act categorizes, different types of contempt of court. So this act, Contempt of Court Act 1971, it refers to civil contempt and criminal contempt. Such contempt means that somewhere the authority of the court is being challenged. Civil contempt and criminal contempt. The same law, in one of its provisions, the law defines what is civil contempt. I repeat, it is difficult to define contempt of court very rigidly, because an action is required to be placed in a proper context to constitute whether such action really led to contempt of court. Because as the context changes, the same words may assume different meaning. So therefore, much has been left under this act, much has been left to the discretion of judges, that in a given case, judges have to decide whether contempt of court has taken place or not. Point is clear? This act categorizes the contempt into two: civil contempt and criminal contempt. Civil contempt means willful disobedience to any judgment, any order, any verdict of the court. Willful disobedience. You are not complying with the orders or any judgment, or any writ issued by, the court. So that is known as civil contempt. There is a willful disobedience. And there's another category which is known as criminal contempt. Criminal contempt means if somebody publishes something either through words or otherwise any kind of the sign or through one other means. It means you publish some kind of material or in words or in spoken form, or some kind of sign or anything or any kind of representation. So you publish something or you are doing something which lowers or tends to lower the authority of the court, or which scandalizes or tends to scandalize the authority of the court. Or for that matter, you are publishing something, you have published something, or you have done something that interferes with the independent functioning of the court, or that interferes with the process of administration of justice. This would amount to criminal contempt of the court. Getting a point? So there are two types of contempt: civil contempt and criminal contempt. In civil contempt, there is a kind of willful disobedience to the authority of the court, order, command, any writ, any decree. You have not complied with that. That is civil contempt. And criminal contempt means that you are publishing something, you have published something, or you have done something that tends to scandalize the courts, or that tends to lower the authority of the court, or that has led to interference with the authority of the court, interference with the judicial proceedings, or for that matter that interferes with the process of administration of justice. That is known as criminal contempt. In all such cases, it is up to the court to decide whether the contempt has taken place or not. And if it is found that yes, your action has led to contempt of court, then appropriate punishment can be given by the court of law. It may be in pecuniary terms. The court may ask you to submit a certain amount of money as fine, or for that matter, in extreme cases, the one who is responsible for contempt of court can be sentenced to imprisonment for a few months, few days. It may also happen, or there can be other types of punishment as well. This is known as contempt of court. Now the question is, why a lot of debate and discussion has kept on taking place. Recently it happened, Mr. Prashant Bhushan, one of the senior counsel of the Supreme Court, he was found guilty of contempt of court because he spoke something which the court found as something which scandalizes or lowers the authority of the court, and accordingly the court punished him with a fine of ₹1. But all lawyers are not so fortunate. Sometimes huge amount of fine can be imposed. In extreme cases, a person can be sentenced to imprisonment also. Then Rahul Gandhi was also found guilty of contempt when he attributed those words to the Supreme Court, "Chaukidar chor hai." So he attributed this expression to one of the judgment of the Supreme Court. So indirectly or directly he said that Supreme Court has accepted that Chaukidar chor hai, but this was wrong. Accordingly, a petition was filed. A petition was filed in the Supreme Court, seeking appropriate orders or punishment, for Mr. Rahul Gandhi, who had done something, amounting to contempt of court. So the court accordingly, Supreme Court issued notice. It happened during the last election, general election. So court issued notice to Mr. Rahul Gandhi, and Rahul Gandhi submitted his answer that what he said did not amount to contempt, but court was not very much satisfied. Later on, warning was issued by the court that you cannot attribute the statement like this to the Supreme Court for your own political advantage or convenience. Do not drag Supreme Court or judgment of the Supreme Court to your own advantage in the political spectrum. Judicial process should be kept away from the political process. So contempt of court, and sometimes we have seen on many occasions constitutional experts and the lawyers have criticized Contempt of Court Act on the ground that Contempt of Court Act creates a kind of deterrence against the criticism of the judiciary, that it tends to create a deterrence so that the lawyers and other persons, they avoid criticizing the court of law, which is very much undemocratic and which is violative of the fundamental rights of the people. They come up with the argument that in democracy we have freedom of speech and expression. If the members of executive, the members of legislature can be criticized for their act of omission or commission, or for their inefficiency, or wherever they are known for deficient performance, why cannot we why cannot we criticize the judges of Supreme Court and High Court? So contempt of court has been a bone of contention, because some lawyers, experts have found it to be violative of the right to the expression of dissent. But on the other hand, many experts hold the view that basically Contempt of Court Act is not against freedom of speech and expression. It is not in the nature of creating deterrence against the criticism. If your criticism is genuine, there is no reason why judges would invoke contempt, the provisions of Contempt of Court Act to punish the individuals or institutions. Why? Because under Contempt of Court Act, there are many things which have been mentioned. Though things are not so much clear, but over a period of time things have evolved, and judges know it very well that criticism of an individual judge per se does not amount to contempt of court. So there has developed a kind of understanding between the courts on the one hand and society on the other. So there is no need of unnecessary criticism. Contempt of court is not against constructive criticism. Contempt of court is against the tendency to criticize courts or interfere with the proceedings of the court, in pursuance of oblique motives and interest. So if somebody is commenting on the performance of judiciary, that would not and should not amount to contempt of court. But if it is found that you are publishing something without any evidence, you are doing something which tends to scandalize the authority of the court in the name of freedom of speech and expression, an individual or an institution cannot be allowed to transcend that Lakshman Rekha or boundary so as to bring disrepute to the authority of the court, because it may have very serious implications for democracy. Why? Because of your deficient knowledge, or because of your irresponsible pursuance of political interest, if you speak something against the authority of the court without genuine evidence, you just you are casting aspersions without any evidence, or you are creating a kind of cloud over the institutional credibility of the Supreme Court. It may have huge implications for democracy. People might think that judges are corrupt and our judiciary too is corrupt like others. So if they end up losing faith and confidence in the Supreme Court and the rule of law, so that may lead to wholesome chaos in the society. People will start taking laws into their own hand. So it means the faith of the people or confidence of the people in judiciary has to be strengthened. It does not mean that the judges are not willing to face genuine criticism. You can comment on the functioning of judiciary. You can come up with a constructive criticism. You can expose if there is a case of corruption, or if there is some kind of inefficiency, if the judiciary is not so much dynamic. You can create compelling circumstances for the government to enact law or to amend laws, to amend the provisions of the Constitution, to devise ways and means to enforce the accountability of judiciary or to pursue judicial reform. There is nothing wrong in that. But there is a limit when you do something without any evidence, unnecessarily in furtherance of your narrow parochial interest. If you question the credibility of judiciary every now and then this cannot be tolerated. So we need to basically, when we discuss Contempt of Court Act and its relevance, basically the entire discussion is about striking the fine balance between the democratic rights of people, freedom of speech and expression, right of dissent, to criticize, etc., and on the other hand, the imperatives of providing adequate safeguards to the institutions like judiciary, so that their independent functioning, or their fearless functioning could be facilitated, because it will have direct implications for our democracy and the quality of life of people and for the sustenance of rule of law. Are you getting a point? So therefore Finally, it is not so much a case of, like having contempt of court act or having no contempt of court of act. It is not like that. Rather, contempt of court act can be amended if required, can be amended to create space for constructive criticism. There is no problem, but we should keep adequate safeguards to discourage undue, uncalled for criticism with oblique motive and interest. Points clear? In this way, we can strike the fine balance. While we can encourage genuine criticism, but at the same time, we should discourage politically motivated criticism, or the tendency to scandalize or to lower the authority of the court. The imperatives of independent functioning of judiciary has to be reconciled with the imperatives of freedom of speech and expression and the right of dissent. Points clear? No institution, I want to make it clear, no institution in democracy can be allowed to function as an island of power. Every institution should be made accountable to people, but the manner of enforcing accountability may differ from institutions to institutions, because every institution is different from other institutions in terms of its goals, purpose and objectives, and there cannot be one jacket fits all kind of concept. Accountability has to be enforced, but the manner of enforcement of accountability may not be the same. It may be in keeping with the requirement,
लेकिन कमिटमेंट कोई तरह से नहीं हो पाता है।